All right, good evening. It is Wednesday, February 11th, 2026, and it is 6:03 p.m., and I'd like to call to order the Keizer Planning Commission. The second item we've got tonight is the consideration of the January 14th, 2026 minutes. Is there a motion on the table, please?
I move we approve the minutes as presented.
I'll second.
We have a motion by Commissioner Grentz and a second by Commissioner Scruggs to approve as presented. Is there any further discussion? Hearing none, all those in favor signify by saying aye. Aye. Any opposed, say nay. Motion passes unanimously with one, I think, absent. Yes, Frank? All right. We got a big audience tonight of no one, so I don't expect we have anybody signed up for testimony tonight, Dawn?
Right.
Great. All right, moving on to the strategic plan. Where's your partner? Where's Dina? We miss Dina.
Dina is not here tonight.
I'm not Sherlock Holmes. I could have figured that one out there, Mr. Witham.
No, they were, she had some family obligations.
Good,
So
good. Well, we're glad
I
to have
told
you
her-
and Mr.
I
Lindsay
said,
here
you know,
tonight, so-
it'll be all right, so.
Tell us some strategy.
Yeah, so honestly, this is really just kind of putting a bow. I know at least three of you were around when we brought the strategic plan before Planning Commission quite some time ago. And we had a meeting about it, we talked about it. There were some input given, which was great. But ultimately, I wanted to bring this back because on February 2nd, City Council officially adopted the strategic plan, and it's a real thing now. And specifically, I just really, I'm gonna keep it brief because we don't need to talk about it a ton, but I wanted to put it in the packet for y'all so you had it. The strategic plan kind of covers the ideas. It's sort of a, oh, guess what? It's a strategic plan. But it kind of basically synthesizes the city as a whole, and over the next 5 years, the things that are looked at as strategic priorities for the city to pursue and do. So there's things about public safety, there's things about like all different things, but there is specifically some elements in there about growth, economic development, housing, those kinds of things. So they kind of touch in areas that Planning Commission, the realm that Planning Commission lives in. And so really, I just wanted to bring it back to you, make you aware that it's adopted, provide it for you so you can kind of look at it, familiarize yourselves with it to the extent that you want. And then also just let you know, like, if you have questions, you can reach out to me. If you have questions tonight, you can ask me, and I can try to make up answers to the best of my ability. But yeah, that's really just the reason for bringing it back. I don't have anything super specific to say, oh, hey, look at this exactly or this exactly, but there are some things in there that talk about housing capacity analysis and the transportation system plan and different things that you all are already aware of because we know that we're working towards those things. But this kind of puts it into the written form. So yeah.
So Shane,
Yeah.
remind those of us that don't deal in strategic plans for a living. This doesn't necessarily carry any force of law as it relates to decisions being made by either the Planning Commission as recommendations or decisions for the council, correct?
That is correct. Yeah, it's more of a higher level. It's really kind of like a policy document, I guess, would be the way to describe it. So, for example, if Planning Commission takes an action and has a recommendation that we'll take to council that is connected to one of the strategic priorities, then I, as the staff person, will kind of be pointing that out and say, hey, and this is actually furthering or helping to implement the strategic priorities that we've already identified. So, but it doesn't, in and of itself, it doesn't like, this is the only thing you do, or this is what you know, business as usual is still a thing.
I think functionally, strategic plans are only as good as the output, in my opinion. And I think what I mean by that is like, as we frame conversations around our transportation system plan, any further master plans that we have, this is a really good document to look to because I think that this is a response provided by the community. It's adopted by the council. And so I think that where I'm going with this train of thought is if we're kind of getting lost, like this is a pretty good place to start backwards and deconstruct the conversation that we're having because, you know, whether or not the council got it perfect in this, it sets sort of a decent cornerstone for the conversation. So, I guess for lack of a better term, you know, when in doubt in our conversations, this is always a good thing to kind of go back to and say, okay, are we generally in keeping with what the strategic plan says? If so, great. If not, why not? And it could be the effect of, you know, administrative rules that come down the line or other things like that just simply prevent us from doing that. But appreciate you bringing us forward tonight. Any other questions or thoughts?
Yes. I have one question, Shane. You've got, we've got the tasks identified.
Yeah.
Who's going to do them?
Yeah,
And what's the timeline?
Sure. Yeah, so the strategic, man, I am having a hard time saying strategic. So the strategic plan, the timeline is kind of a 2026 to 2030 plan window. So the idea is that these tasks that are identified, there will be movement and completion on those. The other thing about the strategic plan to kind of note is that it is somewhat like, I think what Mr. Brown said is a living document. Right. So, you know, it is kind of one of those living documents, whereas things come off the list or things are completed, you know, other things may slide into there and there may be other things identified to do. So I think that, you know, ultimately the strategic plan is something that the council says, hey, these are the things that we want to accomplish as a city. So then the kind of the who's doing what work is, it's going to be a combination of things for sure. But there's a lot of things in the strategic plan that clearly aren't going to be necessarily planning commission being involved with. But like one of them in the transportation, like the first one is complete a transportation system plan update. And so I've kind of told you guys we're at close to the beginning of that process. And so within that transportation system plan task specifically, like I will be a named project manager and most likely our new public works director will be a co-project director at the staff level. Ultimately, the TSP will be adopted by council, but along the way, there will be planning commission involvement on that one. There will also probably, well, I know that there will be an advisory committee, which there may be an invite to have a planning commissioner on that advisory committee. So generally, when you do a TSP, there's a lot of public involvement along the way and things like that.
Well, what prompts the question is I've been around a fair number of these plans. And if you don't assign a timeline and task, they wind up in the bottom left-hand drawer of the desk.
Yes.
And they disappear, and without assignment of tasks, it's a wish list.
Yes.
And
no,
that's what I was.
Yeah, no, I appreciate that, and that's very well said and heard. And I will say, I mean, really, the executive leadership team is, after this was adopted, that was one of our first meetings as a group, was to kind of go through and talk about, okay, where do these things live? And so we've kind of started that process. I mean, ultimately, I guess ultimately the strategic plan, the responsibility lies on the city manager at the highest level, right? Like council direction to the city manager, and then it kind of flows out from there. But yes, there will be some things that we all will be semi-responsible for or involved with for sure.
But functionally, it's appropriate to say that, like, in 11 months, when you come back with next year's work list, right, we can look at this and say, you know, are we tracking to be complete with X, Y, and Z? Also, like, what are we doing to position ourselves to accomplish, you know, LMNOP, right?
Yep.
And so.
I would like to congratulate the mayor and the council for actually doing this exercise. A lot of cities don't do that, and well done, thank you.
Yeah, I mean, absolutely. I was along for the ride, but I think that's absolutely right. You know, I've worked for the city for like 28 years, I think, and we've never had a strategic plan document like this in my career being here. You know, we've had goals, and the council's always set goals, but this is a little bit of a bigger lift and a greater look. So I do think it's a good document that can give guidance, and looking forward to see how that works. So thank you.
Any other comments or questions? No, good job, guys. This looks really good. Councilor Duran, looks like you guys put some work into this at the council level, so. Appreciate y'all bringing it back, and if we can achieve 20% of any of it, we're doing okay, yeah? All right, now for the best part of the year.
Ta-da.
Training on Quasi-Judicial Processes by Mr. City Attorney Joseph Lindsay. Now,
Thank you.
before we get started, I did ask for this because, we have potentially coming down the pike a lot of work, and the reputation of this planning commission is very solid. I think it's, I think Councilor Duran, you and I were around with, just at the tail end of some previous planning commissions where some of the conversations around sacred cows, literally, and some other things was quite contentious, and I think that this body has done a really good job of working through some complex things, but to the best of our abilities, no matter how good we think we are, nothing ever gets screwed up more than process, and that's why I asked Mr. Lindsay to bring this forward, because if we get the process piece of this right, it saves Mr. Lindsay from doing a whole bunch of unnecessary work relative to appeals and so on and so forth. We never want Luba to come back and say we did something wrong on the process. Substantive, fine, but process, if we can avoid it, this is why I asked Mr. Lindsay to do this, because I think it's super important. So I'm going to shut up. Mr. Lindsay, the ball's all yours.
Hey, thank you. And I'll accept court as well if you want.
Yeah, fair enough.
So the one thing I did try to do is just make this, I'm always encouraged to not just blather on. And so I want to brag that I got this onto one page, even though it's two-sided. But what that means too is you could carry it with you to your hearing, because this really does have it sort of synthesizes our rules and the law on quasi-judicial hearings. So this is a nice cheat sheet.
I will make one request.
Yeah.
I really want to see another Shannon Johnson video.
Okay.
In the schema of the Captain American training videos for PE.
Okay.
If you don't know it, look it up. No, I'm
I will.
kidding.
I'll do that.
Shannon
I'm
did a
always-
great video. I was actually teasing him about it last week, but I'm sorry, carry on.
Well, no, it's good. What you'll notice too is that we don't have a PowerPoint. I kind of like having a piece of paper out in front of me,
Yeah.
but also I think, people know how to read in front of them almost better, I think, than sometimes glancing clear across the room to a PowerPoint slide. So, plus I'm just not that fancy. So what I wanted to sort of lay out in front of you guys is the first thing you really want to consider is when the whole reason it's called quasi-judicial is because you're acting like a judge, right? And so can somebody participate for a second and tell me a quality that they would look for in a judge?
Honesty.
Honesty, there you go. Oh, did I hear, Shane, did you have impartiality? Okay. Can you think of
He's
other
got the
ones?
answer book. It's unfair.
Yeah,
Kick him out.
exactly. I mean, honestly, if somebody's going to sit in judgment of you, what would
Yeah.
you want them to be? Do you want them to be biased
I mean, they're in favor now.
or unbiased? Yeah, that's right. If they're your best friend, or even focused,
Yeah.
maybe. Can you guys think of other things? Objective? Did we say objective?
And just so you know, Joe did, in a former life, he was a school teacher,
Oh.
so just FYI.
Yeah. I was. Oh, I know. Well, yeah. Mr. Lawyer. No, so I mean, if you're thinking about the list of qualities that a judge has, we actually have a list of qualities for a municipal court judge. We created a form, and there's about 10 of them that we go down and we judge him on. And so maybe I can produce that for you too, because that's what we're looking for when we sit in judgment of people. Our culture here is to kind of be impartial and unbiased and objective and focused, and taking a level of seriousness with, what you're doing too. So I think those, and then having a good temperament, right? Like a judicial temperament is one of those things. You don't want somebody who's just going to start screaming from the dais. But I think you guys exude a lot of those things when you're sitting here. But it's good to just sort of note. What I will say is, what's different about a quasi-judicial hearing from like when you actually go to court is that in court, there's usually, two parties,
Right.
defendant and prosecution, or, plaintiff and defendant, or
Right.
that sort of thing. Here, they actually, you get party status if you participate at all. So whenever we invite anybody up to come and say anything, if they say something on the record, now they're a party and they get standing to appeal.
Right.
So a little bit different there. And the law says that all of those parties are entitled to a fair, equal, and unbiased process. And so the way the law tries to get to the fair and the unbiased is by making sure that the people who are sitting in the seats kind of do a self-check of what a judge usually does, which is, am I too biased to hear this? Am I conflicted in any way, right? And then am I, have I had any contact that somebody should know about? So before the hearing, and this is according to your rules, I have a script. And there's some case law that has kind of come out of the ORSs that has me read this thing. And so just be prepared that I'm going to have to look at the substantive criteria in the case. And depending on how many of those laws we're looking at, I kind of have to list them out and read that. And then I have to give people their rights. And, you know, if you don't speak up right now and make it an issue, you're not going to be able to appeal that later, that sort of thing, right?
So it's basically raise or waive it.
Yeah.
Yeah.
And so I end up reading that, but then along the way, when I'm reading that, expect that I'm going to interrupt myself and I'm going to now say to each person the three things, right? I'm going to require each of you to say whether you've had any ex parte contact. And so we can talk about what that is. And those are contacts basically where you receive information or discuss the application. And so that assumes that there's an application in.
Yeah.
But I mean, if we know an application is coming down the road, I think that's fair because I think would be actionable.
Yeah.
And so, you know, don't worry about discussions 5 years ago, you know, or whatever. But when you finally know that, say, an ILA is coming down the road, if people have started to discuss it with you, that's when we say, okay, you know, keep that in mind because you're going to have to disclose. Somebody discussed that with me. Now, it might not be any information that came about, right? You might just say, yeah, well, somebody tried to say something to me and I just, you know, put the hand up and said, I can't talk about it because I know I'm going to hear about it. Or formally, if you visited the site. And all those things do is they let people know that, hey, there was additional information or somebody tried to get a hold of me. And so the rules actually say, if whatever that discussion was, even if it wasn't about the merits of the case, say, because maybe they were trying to bribe you, you know what I mean? Or maybe they were trying to twist your arm or coerce you or whatever. So you basically just have to say on the record, this occurred and whether or not you can still be impartial, even because of that contact, or this was the information, and you want to give enough of the information that basically then the people who want to be parties have the ability, when they speak, to address those things. So like, you know, somebody comes up to you and gives you information, hey, I heard, you know, they're really only going to, you know, turn that into a whole bunch of, you know, I don't know, shanty houses or something. And so you say, yeah, I was told this. I'm not sure if it's true, but I just wanted to, you know, put it on the record. And then when they come up, they can say, no, absolutely not. We are going to do what we say we're going to do or whatever it is. So it's just a way of sort of, if there's information out there that might be in your head because you're the decision maker, you want to share that so that people have the opportunity to rebut it. Did you?
I was just going to add, and I think the other thing, and Joe and I were talking about this a little bit, and you know, I'm not a lawyer. I don't live in the legal world, but you know, the ex parte contact, oftentimes, you know, that is said, and people kind of have this, ooh, ex parte contact, and automatically feeling it's bad. And I think the reality is it's not bad. It's just a thing. And so, you know, specifically for Planning Commission, and we've talked about this. I've given you guys heads up. Hey, ILA, we hear it's coming in. ILA is coming in. ILA has come in. There's going to be a neighborhood meeting. There's these different things. And so we've said, you know, hey, be careful about ex parte contact. And I think I may have historically said it in a way that maybe wasn't as accurate as I should have, you know, not really thinking of it. Because the reality is that I think it would surprise me if when we get to the hearing on ILA, for example, that not everybody sitting up here, I mean, if I was sitting in one of your chairs, I'd have to be like, yeah, I had some ex parte contact. I talked to this person about it, you know, because it's out there in the community. And I think that was one of the things I asked Joe about a little bit. I was like, hey, so an example would be, and Joe, correct me if I'm wrong, but an example would be is that, hey, they had that neighborhood meeting earlier And if you went to that neighborhood meeting, that would be considered an ex parte contact.
Yeah.
And so you just simply say from the dais, I did attend the neighborhood meeting on November 16th or 19th or whatever, and heard what the applicant said. One question I had, Joe,
Yeah.
I don't want to interrupt, but it is like education for me too.
I think it's
is-
important, because it's, other than the one, variance, we haven't done quasi-judicial in a long time.
Right, and I mean, and we most likely will have not just this, but we'll also have, master plan amendment stuff coming in for Keizer Station, I think. But Joe, would reading newspaper articles also count as that ex parte contact?
Well, it would be information.
Because
And
it
so
would,
if you
so you would
received
just
any
simply,
information-
so you would simply say, oh, and I saw the article that Keizer Times had produced, or
Yeah.
whatever, and that's all you'd have to say though, right?
And here's the thing, it might be good information, or it might be stale information or misinformation. You know what I mean? And so really you're putting on the record, in my head is this information. So, hey, even applicant, you might want to correct if the paper was wrong. You know what I mean? So literally it really is sort of like a over fairness, because it's part of this, making sure that we do a fair hearing. So, but I will say this, what it does not include, so the second bullet point on that is sort of important. If you talk with Shane about it, that's not ex parte contact. Or if you talk to the lawyer about it, that's not ex parte contact.
How far does that extend?
Well,
So
it says staff in the law,
So
but I mean.
employees of the city of Keizer, does that extend to contractors?
Well, but I would say this. So say, here's a staff member who's in charge of the actual
Right.
process in here. I think that's totally fair to get sort of that information from him. He's going to make you a staff report that you read too, right? And that's going to be part of the record. What is probably not the case is an officer who happens to live right next to the field that they're going to develop. That's more like, you know, a person out in the wild, not because their staff position isn't part of the discussion that's sort of shielded from ex parte contact. Because really, it's like, well, Officer Johnson doesn't want this. He lives right there.
I guess to ask my question directly, city has a contractor on staff.
Yeah.
Right now, that's assisting the city with certain
Okay.
transactions.
Yeah.
Is that individual covered?
Yeah, that's an interesting one, because he's technically acting in an official capacity for the city. And so he is, yeah, I would say he's part of that shield, because he's
Okay.
sort of in that vein.
Okay, that's fair, thank you.
Yeah, because it's about the properties themselves
Right.
in that same, so, good question. But yeah, so keep in mind too, and if you have a question on that, feel free to ask me, just like you did. You know what I mean? Like if you think it's a close call, you might as well say it. It's just gonna be on the record. And it really is a remedy for,
Yeah.
so I've heard of people saying, don't dare do that, you're gonna kill the hearing. No, you just remedy it by disclosing it on the record.
Right.
And then now they have all this testimony time to like correct that misinformation if they think it's wrong.
And the remedy has to occur every time there's the conversation on this, correct? So for example, if we stay the hearing and we come back, we have to reintroduce any ex parte contact at the continuation of that hearing.
It depends, because if it's a continuation, it's the same hearing, so no. But
Okay.
if you had new information that you got in an ex parte fashion, you
So
would.
it's not every, okay,
Yeah.
this is good to know, thank you.
Yeah, because if it technically is a continuation, it's already happened, it's part of
But if
one
it got
record.
appealed and sent back or whatever, at that point,
Yeah.
okay.
And
We'll work through that all later.
And I think the other thing I would reinforce, like, I think if there's a question in your mind, and I think you reach out to Joe or you reach out to myself
Yeah.
before we get to that hearing time and go, hey, so this is kind of what went down. Is that something I should be declaring? And then we get the opinion of him, because really, when you think about it on its surface, and that was something that was helpful for me as Joe was kind of educating me on this stuff over this past week, as we're kind of talking about it, you know, the reality is that the idea of a public hearing and a decision within that public hearing when you're submitting evidence is, you know, from the purest sense, okay, we are this body of judging an application based on criteria and what is spoken at this hearing and nothing else. And like all of us drive by that property. All of us know about that property. Like, I mean, it's impossible not to have knowledge outside of the hearing. And I think the bigger risk is if somebody does not make a declaration of certain things, and then it goes through the process, that could be grounds for someone else to then point that out as a problem where then, yes, we have issues with our process and, it's the appearance as much as anything, so.
Well, and I would even
Just
say
for what it's
this,
worth.
it really is, the contact has to happen really when there's a matter just about to happen or already in the hopper too. So again, you may know 3 ex-owners of a piece of property. Like, you don't have to bother with that whatsoever, right? It's just kind of, there's gonna be a matter in front of you, and has somebody tried to either reach out and nab you a bit to influence you in some way, and might as well put that on the record, or have you been receiving information because you knew it was gonna come in front of you, and therefore it sort of puts the applicant or any of the other parties unawares of what they should be talking about. So does that sort of make sense? Okay, if you have any further questions, please follow up with me too. And then what I did at the end, the last bullet point, is I also made a copy of all of your rules. We changed those in 2025. We changed the time of the meeting, remember, to the actual time you guys really meet. It used to say 7.
Right, yeah.
But everything else is spelled out in there if you're going to do either quasi-judicial or legislative hearings. It kind of has those spelled out too. So, and I quoted those rules here. It says, if the contact, and this is the ex parte contact, impairs the member's impartiality, the member shall state this fact and abstain from participation in voting. So that's pretty high bar. If you really think you know what I mean?
Yeah.
If you can't be impartial, they really got to you. And so that's fair to just say, yeah, I got to sit out then. I don't know if they're taking your family hostage or something in order to get that level of impartiality. So
Before we move on to conflict of interest, I just want to say something that's really important. Declaring the conflict of interest, ex parte contact from Mr. Lindsay, I'm not getting in trouble for it. Where it gets sticky is if he finds out later through other sources that in fact ex parte contact did happen, and then you have to explain yourself from the dais or the newspaper. So just keep it really, really clear. Just because you've had a conversation with somebody doesn't mean you're in trouble, doesn't mean you don't have the ability, in most cases, to not participate as long as you maintain impartiality. Where Mr. Lindsay and Mr. Witham are going to get really frustrated is when they find out through outside sources that in fact that didn't get disclosed. Is that accurate?
yeah, well, or, I mean, you could come up with an example that would be kind of embarrassing, right? So you didn't say it on the record because you're like, eh. And then after it goes forward and there's a side that likes it and a side that doesn't like your decision, right? And then during the appeal period, it comes out that somebody you did talk to goes, hey, I talked to him and he said he wasn't even gonna vote that way.
Right.
You know what I mean? And now that ends up in the paper and it also ends up in your appeal. And so that's sort of the most embarrassing way for that to come out. Isn't just me saying, don't do that. Because I'll try to protect your decisions to the best of my ability.
Right.
But having somebody who's against you have sort of fodder to shoot at you is not great. So conflicts of interest are the next way in which you want to make sure that you're having a fair and impartial judge sitting up there. And conflicts of interest are sort of interesting in that they're not as, they probably aren't as prevalent as you'd think in a way. But also, there are some caveats to them that I think you want to know. And so there are 2 types of conflicts of interest, and the one is you have to declare it and not participate in either the discussion or the vote, and that's the actual. And an actual conflict is whether or not whatever this decision is actually would result in either a financial gain or, or loss or, avoidance of a detriment for you, your family, and the family's actually sort of limited. It's not like third cousin.
Right.
So you don't have to declare third cousin's gonna make money because he works for this company. It's really, and if you want to look under the definition of relative that gets applied to this, it's in the ethics rules, it's ORS 244-020. But it really says a relative is a parent, a child, a sibling, so really close, or the in-law versions of those for either you or your spouse.
Right.
And then this last legislature, the long session, they extended the ethics to also be to a member of your household. So, which is weird, but like if you have Cousin Jerry living with you, then now Cousin Jerry would be part of that ethics analysis. But otherwise, or even Gus, your neighbor, and he's down and out and living in your house. So he's now part of your household. But so the analysis is really, would he make money or a business that he works for make money? Or would they avoid losing money? Would he, and so those are the things that you're looking at. And that's would absolutely. So they're in here and, your wife's company is here wanting to do some work and they're going to make money on it. That's obvious. But, you don't have to declare, because some people think like, oh, a guy that I treat like a brother, he might make money, have a conflict. You don't. So just keep that in mind too. And if you have a question about that, I can help you with that definition. So it's not like you have to open up the whole world of like, I just can't do this because, and this is even further sort of sussed out by the idea that potential conflicts. So if it would, it's an actual. If it could, it's still only a potential.
Right.
And so, like, how do we know what the universe of, absolutely woulds versus could? And there's an even provision with the potential, so it's the same sort of parameters. It's you or your spouse, and then the close relatives of those, or the member of the household, that could make money or could avoid a financial detriment in their personal life or their business. And, but there's provisions in the ethics code that say that's still sort of softened because the world's too big if it could. And so there's actually provisions that say, basically, if there's an effect that would be to the same degree of like an entire class of people, then it's not a could. So you're a builder, right? He's a builder, so a rising tide rises all boats, right? So building is going to increase all property values, so now my building's going to go up in value. You know what I mean? Like, you don't have to do that. So if there's an entire class of like, I work in real estate, whenever we sell higher, all the real estate goes up. So I'm technically, going to make money off this. You don't have to do that. Like, that's not a could. The other coulds that are sort of interesting is some people say, well, I have a 401k that has like S&P 500 exchange traded fund in it. And so I have all 500 top companies in America. So how am I gonna, I'm gonna make money if these guys make money. And the reality there is it has to be either a closely held corporation where you have like $1,000 or more in either some sort of stock interests or options or things like that, or a publicly held one, $100,000 worth. So it isn't like you have to disclose like, I probably have, $10 in this company, so I can't sit in judgment on it. That's not the case. So, I think those are sort of interesting things to think, because the could really isn't, it's not to hamstring you guys. It's just, there's like, the law tries to be reasonable and fair. So does that sort of make sense?
As a hypothetical.
Yeah.
Commissioner Witters does beautiful hand-carved newel posts that he does as a hobby. I'm kidding.
Oh.
He actually does do that. But let's say, for example, he gets commissioned after the sale of everything and they're building something.
Yeah.
He doesn't know at the time that it could have theoretically been, so there's no actual, right?
There's no
At any
actual.
point. Okay.
No, in fact, because that is still too speculative.
Correct.
Yeah. But yeah, if they off to the side said, hey, if you vote for this, I'll use your carvings, then it's actual.
Okay. So we don't have any real estate agents, but for example, if, let's say, this square block between Rickman and Bailey were partitioned out and people were to start buying things and making money off the sale of that, if they were part of that contribution to that subdivision, they didn't know at the time they were going to be commissioned to sell those properties.
Yeah.
Okay.
Yeah, so I mean, if you're in contract with somebody, obviously, or if you currently work for them,
Yeah.
I guess the closer, those are all personal, and this is where I did highlight, if you notice, under actual conflicts, I have the little also personal ethics, and I have the 244020, if you wanted to, look at that. I mean, if you were to use or attempt to use your own position, and that's on you, because your individual ethics are your own, then, you could receive everything from a slap on the hand up to a $5,000 fine or training or whatever it is. But yeah, so you wouldn't want to do that either.
don't sell-
You know what I mean? Like,
don't
it's
sell
easier,
loopholes.
if you really, I guess even if you wanted to, if you thought you had a real shoe-in for that deal, maybe you'd want to just say, you know what, I'm going to sit this one out, because why risk it? You know what I mean?
I'm not
'Cause-
going to ask Commissioner Witters to sit another meeting out.
But you get what I'm saying. Like, you can also be realistic about life.
Yeah.
So if you were the one person in the area who does that particular work, I mean, I would just probably step away, because what does it matter, right?
Counselor Duran, you have a thought?
Yeah.
Well, I just wanted everybody to know that even if you do this right, you can still have a complaint against you.
Yes.
And it
No.
can drag out for 9 months.
And it's unnerving and embarrassing, and then people always think like, well, you got away with it. They don't think like innocent until proven guilty, which you're supposed to, right? So, I mean, the idea there is, even if he wasn't truly contacted until after the vote, so he's going to have to potentially have somebody complain about it, and then potentially have to, try to disprove the negative at the,
But I think
ethics
that
commission.
example is super important, and I think the reality of it is like, if you do the right thing, the side of the law and the way this works out is going to generally be on your side. And so, Councilor Duran, thank you for bringing that example up. But yeah, it's one of those things like, don't get yourself, if there's even a question, at a minimum, just declare potential.
And
Because you can't be, like, even if your wildest dream, like, you're like, all of a sudden, something, declare the potential, it doesn't preclude you from being part of it.
Yeah.
And if at some point in the hearing, you feel just painfully uncomfortable with making a decision, just say,
Yeah.
look, I declared the potential in at this.
Yeah.
Things I've heard up to this point just really make me feel like I shouldn't participate in the vote.
yeah.
You're not gonna get in trouble for that.
Well, and the other thing I could point out too is if we had a numbers problem, we have good attendance in Keizer.
Yeah.
I've been to other cities that don't.
Right.
That they're lucky to get a quorum sometimes. And so people come in and they have their whole thing ready to go. And then they're calling up trying to find a fourth member so they can actually have a hearing on time, right? So we don't usually have this problem, but there is a provision because the law recognizes
If
that.
if you have it for a
If you
quorum.
had to vote, even if you had an actual, if you had to be a vote, they say, okay, then don't participate in the discussion, but if you have to vote, you can vote. So it's also sort of a backup plan. So this isn't like, it's a civil penalty for one, it's not. And it's
Well, the Court
usually
of
the way
Public
they
Opinion
ratchet
is
it up,
worse.
not to water down what the Ethics
Yeah.
Commission does, but I mean,
No, and the court of public opinion on this is actually the biggest,
Yeah.
drag through the mud piece thing,
Yeah.
right? Like, I mean, I know the circumstance that happened that Councilor Duran's talking about, everything was 100% above board,
Mm-hmm.
but the feelings and the attacks that end up happening in that space are not awesome,
no,
especially when you did the right thing.
yeah. Yeah, and it's still an affrontage and an embarrassment, right? And I think our forefathers, those were like some of the biggest things, like privacy, embarrassments, affrontages, those were like half the reason we set stuff up the way we did. And those don't feel good, so, and then, but for potential, you can still, I mean, if it's just could, like, I don't know, I'm a guy who builds, specialty whatever, and I could benefit later on, but right now I don't, then you're fine, you can participate. But if you have that situation, you could declare it. You'd be like, heck, I'd love to work for these guys someday, but I don't know, so I'm gonna participate. You know what I mean? It's that easy, you just make it what it is and move on. Do you guys have any more questions about actual or potential conflicts?
The only thing I'd say is if you're on the fence on any of it, contact Shane or Mr. Lindsay.
Oh, yeah.
And if you feel like you want to have that conversation off the record, just please reach out.
Oh, for sure. And if you even have an inkling of it, hit me up ahead of time and, you can kind of prep, this is how I'm going to say it.
Yeah.
So it makes it less of a sting. You can write it down even or whatever, so.
Yeah, and I was just gonna add one thing, the focus here is on how the process for a hearing works and what you have to do, and, ultimately, those declarations are gonna be in order to participate in the hearing to show that you have that ability of impartiality. I think the follow-up piece, and this is why I would definitely encourage you to reach out with any of those questions, and really, on this stuff, reach out to Mr. Lindsay, because I can't give you the right advice. Because the flip side is when that hearing is all over and done with, and then, oh, they're doing this thing and my company does this, so I'm gonna put a bid in for that. Like, then that is no longer, has nothing to do with the hearing, it has nothing to do with any of that from a process perspective. It has everything to do with your personal ethics at that point. So it's kind of two different things. Like, our interest is protecting everything, but really our interest is in protecting the validity of the
decision-making,
approval or denial process because of the appeal rights that go along with that. So just, anyway.
And, well put. But the other thing is, yeah, if you talk in advance, the nice thing about talking to me is that I'm not gonna go blabbing. Right? Like, I'm here to run an idea off of and or get a little bit of a nugget of how you can proceed without it going anywhere else, so, okay, cool. So bias is the other thing, and bias is pretty funny because it's also a very high bar. It's sort of like, I jokingly said about how could a contact make you so impartial that you can't participate up above. There's the exact same sentence in your rules about bias. And so the rule is basically, if the bias impairs the member's impartiality, the member shall state the fact and abstain from participating in voting. But I mean, that has to be like, I hate this guy's guts. I mean, I wouldn't say that, but I mean, if you just said, I feel so strongly about this, I cannot participate, that would probably be the better way of saying it. But I mean, you'd have to, because really what you're saying is, no matter what I hear, I'm voting no, because you know what I mean? And that would be pretty biased. So yeah, maybe you wouldn't want to judge like that against you. So, you know what I mean? Same idea.
And the same would go for yes votes.
Yeah, that's true.
No matter what I hear, I'm voting.
Yeah. Well, and to be honest, we are asking both sides of the coin. If they meet the objective, clear and objective criteria and supply the evidence to show that they did that, then you basically objectively have to say yes. And if they didn't, even if you love it, you objectively have to say no. So, I mean, you really, being objective is important and unbiased. So, the other thing is, with biasness, I think some people want to read into their own bias. I think people, there's language around bias now that we dig way down deep into bias, like we have implicit bias. We don't even know we have bias. This isn't that at all. This is like raw, in your face bias. This is like, and you are actually allowed to have those other little biases that aren't really, it basically is you can have your own opinions, you can have your own experiences from life, you can have all of that, and you don't have to unearth those on the record. You don't have to be like, you know what I mean? Like, you don't have to say, well, I don't know, I never liked development anyway. You don't have to say that. Because really, you have to just judge yourself, can I be impartial?
Right.
Or am I so biased that I can't be? And so it's a binary thing. And so if you reach that threshold where you're like, you know what, I'm not going to participate in this one, like, I've already prejudged, then yeah, by all means, call yourself biased and leave. But you don't have to hammer yourself and find a bias if it doesn't exist. And to the level that you can't be fair. So, make sense? Any questions? All right. So after that, there's a little more script reading about the process and the expectations, and that's even the explanation, which is the following. The way I broke this up, I thought it would be more interesting to have it broken up into what do you have to do kind of before the hearing,
Right.
and then what do you have to do during the hearing, and then how do you close out the hearing or after the hearing. Yes, Mr. Lawyer.
When you say before the hearing, and this is just semantics,
Yeah.
but we would be in the hearing to disclose all of this.
Yes.
Correct?
Yeah.
So this is technically more at the start of the hearing.
Yeah, but the way the hearing is, the hearing is the part after, there's a record, and
Oh,
the
got it.
record's
Okay.
larger than the hearing.
Okay, I'm tracking.
So the hearing is the middle part.
Right.
So that's making a record of.
This is sort of the preamble to the hearing.
Yeah.
Got it, okay.
And so that's part of the record, but the hearing itself is when they're presenting.
Right.
Because that's the evidence that's coming in, and the burden's on that applicant, and they have to present during that time, and that time really only.
Thank you for allowing me to clarify.
Oh, yeah. No, and thank you for the question, because I think it's a weird distinction, actually.
Yeah.
Because you think you're here, and so it's like, and maybe that's where we're different than a court.
Well, the
'Cause a
hearing
court-
actually starts when Shane starts doing a staff report.
Correct.
Yeah, got it.
And so now we're in the hearing. So I read that whole script because the rules say I have to, but also because the law, I've got to have some touch points for the record. And then that builds our record. And then when you open the hearing, okay, now we're going to boom, open that hearing. Then you hear from Shane, the staff report. Any questions you have of him might be answered by the applicant, but if you have them, you might as well ask him because then it puts the applicant unawares. Maybe I wasn't planning on touching on this, but maybe I need to be saying this stuff, right? Because they're already asking about this one thing. So feel free to ask questions. And then it doesn't technically cut into their time because the rules really do have these time amounts and we don't exceed past that really. So if you interrupt them with a whole bunch of questions during their time, it's gonna, if you've ever seen like Supreme Court hearings, they get like that half hour and it's literally down to the second. And they can interrupt you with questions the whole time and you're trying to get your point out and suddenly that, you didn't get half your arguments out there. So if you do have questions, you can use his staff report time a little bit. And it might even telegraph to the folks out here what they might need to address more. Because if you've done your reading, you probably know what the issues are in your head. And then these guys might bring up some stuff. I mean, that's what a hearing is all about. They might bring up stuff that makes you think. So,
And largely, they're going to be arguing against conditions that Shane probably
yeah,
provided.
yeah.
They're going to say, well, we don't like this condition, here's why,
Yeah.
et cetera, yeah,
Well, or the neighbors are.
right.
What do you mean you should, they're gonna build 6-foot fences. We want them to build 5-foot fences.
Right, right.
And what you want to do as the body is, in particular the chair, is just direct them back to the criteria itself. Because again, and this is where, people can come up here and they can talk about those sacred cows, right, that you mentioned. They can be like, but, if you let them build it to the height that the code allows, even though the code says 20 feet or whatever, the shadow's gonna cause my garden to not grow as well, right? That's not really part of the criteria.
Right.
Like the height is, but not the garden ramifications, right? So if they get going down that road, feel free to correct them and say, you know what, we really have to talk about, although in a sense they're talking about the criteria, but you need to know what's relevant to that criteria. And so now we're on officially the second part of page 1, or otherwise known as page 2. Where after everybody's given their, applicants got their 20 minutes, and then everybody gets 5 minutes to shoot holes in it, and then they get their 10 minutes to rebut whatever was said in those 5-minute segments. Then you guys, you have the power and the ability and the, I guess, the necessity to ask good questions. Because that's where the hearing itself is all about the questioning.
Right.
And so once the questions cease, you have to, the rules say, if there's no more questions, that's when you close the hearing. So now you don't have to hear from people anymore. And then in extraordinary circumstances, I guess you can reopen the hearing portion if somebody really wants to come up and be heard. And there's another few places, and this is sort of the wonkiness. This is one of the more complex portions of it, which is the tail end of the hearing and the after the hearing portion, where people have a right to ask for, the record to stay open so that they can, for certain statutory amounts of time. And so that's probably the first essential piece of this is, you're asking your questions, you're making sure that basically you're trying to help them along a little bit. Judges do this for pro se people a lot. If they're not slick presenters, maybe they don't even know how to get their whole point across. And technically the staff report's part of the record, so that's fine. You can make it part of the record, right? And so that's in there and you can make your judgment calls on that evidence as well. But really, if there's a piece that they need to address, maybe you're asking that question, just to be nice and to give everybody in the room the opportunity to also rebut it. Because whatever their answer is might not hold water too. So just part of a fair process. So, but near the end of that questioning, you know, your ears want to sort of go up and you want to see whether or not it sounds like there's not really enough evidence to really push the thing. You know, maybe people want to, it sounds like maybe you want that 1 week extension, right? To maybe supplement the record. And if you do that, then you have to give an equal amount of time for any rebutting of that. So,
Does an extension have to be subject to a particular condition, or, I mean,
well, it says in the law that, yeah,
I mean, I'll give you a real world example.
Yeah.
When the comp plan zone change happened on the Verta property,
Right.
there were requests for the record to be held open to provide additional information. One of those was around the historical element that got brought up, and there was a lot of questions on that. And so Mr. Grenz might remember, because he might have been, were you at any of those hearings?
I don't think so.
No, was it Mark? Okay. I don't remember if that was driven by the applicant's representative to request the extension, or if it was actually driven by the neighbors who were requesting the record to be held open, because essentially there was an issue raised about the historical prominence and significance of that house. And so a record got held open for a certain number of days that anyone was allowed to submit additional written, it wasn't verbal, because we weren't going to have more talking at the hearing, but it was to allow additional written information to be submitted by a date certain. And then all of that information was compiled and done so that then the applicant had a certain number of days to provide a rebuttal
Yes.
to that information, because that is one of the key things with the hearing is the applicant gets this 20-minute time to present their case, which most applicants don't use it because I do such an amazing job with the staff reports. I was kind of joking, but
you actually
it
do
is
carry a lot of
actually,
it.
I do carry a lot of the water. But then, you know, people come up and testify for, against, or ambivalent to the application, but they raise a bunch of stuff, and then they get time at the end to then come up and talk about things that, it's a rebuttal time. So a lot of times that's when the applicant comes and they heard somebody say this, and so they want to bring that up.
Yeah.
But then maybe due to questions from a hearings officer or a decision-making body, they may request that record be held open because, you know what, there was a lot of talk about traffic. We're realizing that we would like an opportunity to get some more detailed traffic engineer report submitted into this record as well, or something like that. So, I mean, but I do think with that property, because I feel like the record got held open a couple of times. It took a while.
Well, and there's sort of two ways for this to happen. The one is before the close of the actual hearing, they could ask for, it's about 4 or 5 bullet points down from the top there, the PC rules. So your rules actually say, subject to state law, the chair shall close the hearing if there are no further questions. The record may be left open pursuant to state law. The time frame for submittals to the record shall be clearly announced prior to the close of the hearing. So that's even before, you know what I mean? So before you gavel down, we're not hearing any more testimony, boom. That's allowing the record to remain open. There's another way later on that you'll see a continuance of the hearing, which is also a way. But just thinking about leaving the record open, basically, if you leave the record open for a certain amount of days, like 7, you have to give that rebuttal period to
the
the
parties,
applicant. And so you'll see down below the last 2 bullet points under there, where it's the ORS that applies to us cities when we act like this, is the local, unless waived by the applicant, the local government shall allow the applicant at least 7 days after the record is closed to all other parties to submit final written arguments, which is a little different. So if they want to literally make an argument in writing, before you make a final decision, you have to allow them to do it, which is a little weird. But so that's one of the things that we have to sort of make sure that they waive it. So, hey, do you want us to decide this now? Are you feeling good about this? You know, do you waive your right to put this in writing? You know, your final argument. So that's one of the things. And then the second part is, that other piece is just the idea that they have to raise stuff at this portion in the hearing, or they don't get to argue it on appeal. The other way, though, if you look now to after the hearing, and now here's where it gets a little confusing, right? Because now we're talking about hearing versus record. We're talking about keeping the record open versus continuing the hearing. And the odd part is, if you guys do want, or if somebody even asks for a continuance, then the law is a little bit different here. It says, our rules basically say that you shall grant continuances as required by law, so I looked up the law, and it says, basically under that, if you allow this continuance, you have to say the date, time, and place, and it has to be at least 7 days out from that initial hearing.
Right.
So you do have to give them a week. You guys probably won't want to necessarily meet we won't meet in a week. But here's the problem with some of this stuff. If somebody gets 7 days and then they get another 7 days and then they get rebutting 7 days, right? Suddenly the 120-day problem starts to look a little more compressed, right? Because you have to make a final decision in 120 days. Our rules actually say any continuances, if an applicant asks for more time, then we basically, that presupposes that that's going to result in an extension of the 120-day limitation. So that's our rule. I wouldn't want to just argue that rule just on its own necessarily, one of our local rules. So I would also just say, we'd probably want to get a waiver on the record that says, hey, we're granting this continuance. I don't want to get a 120-day problem. Are you willing to waive that 120 days and call it 150 days? So those are always good moments to sort of extend that clock a little bit. But yeah, so if they're asking for a continuance at the end, and some people will, because they're like, oh my gosh, you know what I mean, the hearing closed and I didn't ask for it to be left open, but actually there's this other way I can do it, which is a continuance, then you're gonna have another hearing. And then any person, okay, so if you grant a continuance, then any person after that, basically, new evidence is presented, because they might not have enough time when somebody comes in with new evidence. You know, you say 7 days from now, fine, we're gonna have this continuance, and they show up, the law gives them a little grace period. Anybody who wants to argue with that, they get another, keeping the record open for yet another 7 days, to kind of rebut any of that evidence that they hear at that continuance hearing.
I'm just really glad Commissioner Grants is memorizing all of this and is going to be able
Yeah, well,
to my phone a friend during the meeting.
One sheet of paper, right? So I mean, this is where it gets a little tricky. So if you get to the end of your variance, you know, one of your easier quasi judicial things, and they're like, no, I'm good. In fact, Shane said everything he needs to, you know, then, and they're not asking for continuances or whatever, then you're just going right into the decision making.
That's right.
Yeah. Where it gets tricky and where you guys might have a little trial by fire is there's going to be much more complex master plan amendments coming down. And there might be a lot more criteria that you're trying to deal with, and there might be a lot more questions, and maybe whatever's presented in that packet doesn't quite give you guys what you want, and they get a sense of that. And so in those cases, maybe be a little more prepared, like, okay, are they asking to leave the record open? Great. So I'm going to leave it open to a week, and then I'm going to give another week for anybody who wants to fight that. Does that make sense? And what we'll do is we'll send it out to interested parties so that they can send it in if it's just an opening of the record. If it's continuance, then we're showing back up again. Yeah. So that's sort of the way we end these things.
And Joe, can you talk to us a little bit about, like, when they do drop into that deliberations time?
Yeah.
So at the beginning, when I give a staff recommendation, and I'll kind of lay out everything
Yeah.
to a certain level, but also like the whole big, huge written report is officially part of the record, they can ask me as many questions as they want.
Yeah.
At the beginning.
Yeah.
During the deliberation time.
Yeah.
Can they ask staff clarifying questions? Because they can't take new evidence,
Yeah.
but like, I was just curious if you could speak to that just a little bit.
Well, hopefully you're answering in the way that you understand from your packet. Or even, remember, he just testified that, this was the case. And so it's really not new facts, it's arguments. And those are treated differently, right? Because evidence is really facts, and arguments are the arguments that you make from those facts. And arguments are not evidence. People mess this up all the time. like what something actually means is more argumentative. What something is, we are supposing that we're going to make this thing 20 feet from here. That's just a fact. The argument is, and that's plenty of feet for you to drive a truck through. That's an argument.
Well, and in deliberations, if we have additional conditions, that's where we would
Yeah.
be.
And if he can answer that, I mean, we've had this, Councilor Duran, you probably know this, we've had to reopen the record and do continuances in the same hearings, because it sounds like there wasn't enough, evidence presented, and there was genuine questions that they needed in order to answer it. And so the safest thing was, are you guys prepared then to reopen the record? And
So for example, if we're going down the path of a particular condition that the planning commission feels strongly on, and the applicant's over there dancing their pants, we can say, we'd like to reopen the record and invite the applicant to come up and
Yeah.
comment on a particular.
if it's going to be
condition being
new
discussed.
evidence. So if it's in your packet already, you wouldn't have to necessarily take that step. Because
Okay.
you could say, I would point you to page 23 where we talk about that in a big chart.
Right,
And so it really is only if it's new evidence
okay.
that you want in the record. And sometimes those things are just sort of judgment calls, right? Because if you're asking Shane, it's pretty much probably in the record because he's put it in a, 80-page document. Well, yeah. Whereas some other people, they might want to tell you, oh, no, actually, it was only going to be 43 units of whatever. I had one time where there was it was part of this development was going to be memory care, and part of it was going to be like a little bit less care. And it really was, how many memory care units were there going to be, because was there sufficient parking, because memory care doesn't usually drive, and so parking became an issue. And then suddenly they wanted to be like, oh no, I was going to tell you, we actually are going to do 50 units of the units are actually going to be memory care, so we don't need as much parking because we have 100 units overall, or what, So something like that came back, and that wasn't apparently in the record, and so they needed to make sure and get it in there. So I've seen it reopen for that. But the other thing is, it's always good, and I always say this mostly if you're going to be refusing something, because that's where the person with the most dollars is sitting there. And we want to know as staff what your consensus is around the findings. So as we're working towards findings at the end, somebody might say something like, I don't even think that's going to be whatever, you know what I mean? And a couple of people shake their heads, and then you kind of move on. Do 4 of you actually believe that doesn't meet that criteria? You know what I mean? Like, we almost have to stop and be like, of those criteria, do you think that they didn't meet this? And so at the end, after your deliberations or as you're deliberating, it's really helpful to know, because if we have to go back and write findings in a final order with, actually what a majority of you think, and the old Supreme Court, the Lindquist Supreme Court used to do this all the time. Part of the opinion would be these 5 judges, and then another section of it would be these 5 judges, and then there would be 6 that would sign off on this argument. You know what I mean? Like, we almost have to go through each finding. If it's going to be controversial, then I think we do want to know, does a plurality of you, how many are up there, right? So majority of whoever's up there, do they really, are they thinking that this is a finding that they are going to get behind? Because we don't want to show back up with a document saying, you didn't meet any of these, and you're like, they met those and that and that. We just voted no because, they didn't meet this and this. So we sort of want to know what they don't meet in that case. But similarly, I guess, the reason, if you're gonna approve it, we can't assume that all of those findings they met, right, or all the criteria. Now, you might also have a reason why you like that criteria, and you might want a little bit extra in the findings, but that's usually less common. So it's usually when there's a dispute as to what you don't like, that then we want to know kind of in particular why you think it didn't meet that. Especially if staff is writing
Yeah.
that you think that you found it.
Yeah, and I think the most practical application probably, and I think, Mr. Lawyer, you were kind of getting at that. I think the most practical application where I've found this to be not an issue, but where it comes up is there may be in the staff recommendation a bunch of findings that address the review criteria, and then a whole bunch of proposed conditions of approval that assure that that review criteria gets met when whatever project gets developed. And so when sometimes a governing body or a hearings officer wants to modify those conditions, those are generally the areas that we need to make adjustments to the findings. Because like very simplistic way of looking at it, like if you have in land use, which Ms. King would back me up on this, I think, I hope, otherwise I'm doing things wrong. Generally in land use, if you have a condition, you better have a finding that supports why that condition is there.
Right.
You can't just willy-nilly go, you know what, we want all buildings to be blue just because we said so. Like, you know, we're not king for the day, right? I mean, it is literally like, it should be tied to the review criteria, and then you have this condition to assure that that criteria is met. So anyway, just for what it's worth, so if there's things that as you're taking testimony from either the applicant or citizens that are either for or against or ambivalent, and they raise things, and in your sitting in judgment on the application, because Shane is pretty good, but I'm not perfect. And so I miss stuff all the time, I'm sure. And so if there's things that are like, you know what, we don't feel that this condition adequately assures that this criteria is going to be met, those are the kind of things where that direction will be needed so that findings can be, I will say, beefed up or written to address the justification of those certain conditions.
But they're still confined to what the development code allows us to
Still
do.
confined to the review
So we
criteria.
can't just say, look, we really feel strongly, the development code says this, but the planning commission says, we really just want it to be this. We're still bound to what's in the law. as it is
Yes.
right now.
Yeah.
Yeah.
I have a question kind of along the same lines. So in our hypothetical hearing, and I'm kind of looking at bullet 2 that says they have the burden of proof that it conforms to all applicable standards and criteria. So there's a list of, let's say, 10 items that they need to show, or they're arguing that they're conforming to, and in my opinion, I have found that they have conformed to 9 out of 10 of those.
Yeah.
Am I then, not required, I don't know what the right word is, but should my vote be no then, because there is that one, or do I have, or because they've, you know, the burden of proof, they've proved they've met it on, you know, a majority of the items, do I
Yeah.
have the right, or what have you, to vote?
Well, I would say if you have that situation, please deliberate.
Yeah.
You know, don't keep it a
Yeah.
secret. So say,
We can
I'm really
create
worried about this. I don't think they
conditions
met
that
this.
help meet that.
Yeah, exactly. Because the other thing, I've seen this happen too, and this happens in his office all the time with stuff that's more administrative, is you work through problems, right? So as you guys are working up there and you're kind of thinking about it, you know, and is there a condition that will help us feel like we've all met it? You don't have to have 100% unanimity, but you, as a group, you kind of get it right, kind of like a jury does, you know, or in this case, it's like a judge jury in a way, right? Like you're all coming from different walks of life and you're trying to get it right. The other thing I've seen, literally, I've seen an applicant acquiesce and go, actually, if this is such a big deal, I'll just build a fence in between. Well, or I'll build a sound barrier if that's what it, I've literally seen them just give in at that moment and just on the record say, fine, I'm good with sound barrier if you put a sound barrier in. You know, so,
At that point, it may not actually be in the development code, but they're like, to cure this issue with neighbor X.
Yeah.
We're just willing to do this.
yeah. And so if they say, well, if you guys make that a condition, we'll do it, then that might fix that problem.
So that then we could, as part of our decision, kind of have our own conditions on that. If you
Yeah.
build that sound barrier, then you will have satisfied everything, or what have you.
If you feel that a condition is not being met and it helps meet that condition. And usually the criteria that we have will lay out what they have to meet.
Yeah.
And what you can't do is make a sound barrier for something that, arguably doesn't need it.
And I mean, yeah, I think that's, and ultimately, Rob, that is kind of like, that tends to be worked out a little bit in the hearing when the testimony comes from the applicant and from the neighbors. Ultimately, staff, so, you know, with these processes that we're going to be going to, it'll be a heavy lift for staff. You know, specifically with the I Love A piece, you've got very clear and objective criteria that are like building height and setbacks and things like that are quantifiable numbers. But there's also criteria for the master plan approval that says it's meeting the purpose and objectives of the River Cherry Overlay District, Lock Haven Center. And those are still, I would still argue that those are still clear and objective standards. But there is a piece of a burden of proof for the applicant to show how they're meeting that with their development proposal, and a burden of staff to be able to synthesize what they've submitted and what the governing documents imagine and say, is this correct, essentially? And so there may be in a situation like a master plan approval, which isn't like a partitioning, which is very limited criteria, or a lot line adjustment is a great one. 5 criteria. Like, are you starting and ending with the same number of lots? Yes or no? Do the lots meet the dimensional requirements? Are they legal lots? Does it preclude anybody's access? I can't remember the 5th one right now off my head, but I know, sorry, I've done a lot of them, but I'll think of it later. But like that one is it's a very cut and dried staff level, which is also why we don't go to hearings with them, to be fair. But in this world, there may be some things where there are conditions that are like, you know what, that condition may not contain quite enough specificity to give you all the assurance that it's going to meet the criteria that it addresses. So, you know,
I think
I'll try to make sure that the conditions are awesome and
Couch, one of the
perfect.
things that Mr. Lindsay said earlier, if you're questioning something, the 8th out of the 9th condition or something, that's where the consensus matters. And if it's 5 and 4, or, 6 and 3 or whatever, your choice at that point would be whether or not you want to vote for it, knowing that you're not satisfied with that condition, which, I mean, I don't know how that works, but at any rate, it is better, I think, as what Shane and Mr. Lindsay said, to work through it so we can find maybe not the perfect solution to that last condition, but something that certainly is more palatable to the planning commission as a whole.
And Chair Lawyer, if you don't mind, it goes back to the kind of the premise of your question, which is the applicant does have the burden of proof. So again, if you raise something like that and everyone looks over at the applicant, like, what are you gonna do about it? And they haven't provided an answer, and there is no, I would like a continuation to fix this, or I would, you know what I mean? Like, if there really isn't a good answer, it's pretty valid, and it sounds like maybe they didn't meet their burden. Because it really is their burden. They're coming in asking for something. And you guys are trying to sit here going, I'm not gonna help you along to the point where I'm doing your job for you.
Yeah. So for example, in like conditional use permits, if there's, typically a condition is there's not any adverse impact on, water quality, air quality, soil quality, or neighbors or something like that, or property owners, if they can't show that there's no, or, if they can't show that they meet that, then at that point I would be like, hey, I'm not seeing that the applicant's meeting this criteria. What are your thoughts on it? To all of us, and if we can't get to that point where they're meeting that specific criteria, or we all feel that they are, or the majority of us, then it would essentially be a denial based on the fact that they can't meet that criteria with the majority of our vote.
And to Commissioner King's point, if they fail, they literally could go back and reapply.
That's right, yeah.
You know what I mean? It doesn't mean it kills everything, so it really isn't, you don't have to feel guilty about if they come in here and they haven't thought it through completely. You know what I mean?
Right, and I mean, and again, we're talking about all quasi-judicial land use decisions, some of which you are the decision-making body. On these master plans that we kind of know are coming in, you're a recommending body. So it may be that the recommendation that comes out of Planning Commission, it could be a recommendation for denial. And then there's going to be another public hearing at the council, because the city council is actually the decision-making body. So that's the other piece on,
Well,
you know, I think there is a nuance. When you're the final decision, the continuation of public hearings and those kinds of things are going to be really, really, really important, because once it's done, it's done. In this case, the specific master plan scenario, you are making a recommendation that is going for another public hearing, which essentially restarts that process to submit
It
evidence and
does.
things like that.
Yeah,
So
it's
so I don't
de
think
novo.
you don't have to worry quite as, I guess there's not as much stress that has to happen of like, oh goodness, if we don't do this exactly right, you know, whatever. I mean, you're going to do it exactly right because you're the planning commission. You guys are great. But just for what it's worth, just because we've been talking about this kind of master plan example,
Yeah.
which, yeah.
Yeah, you can feel free on, and it would be great for the applicant to hear that they didn't meet the mark with you guys on this thing, so that when they go de novo to the, you know, in front of the council, they can fight your recommendation if it's for denial. You know, they can say, well, we've addressed that now. So,
Well, and I just want to reiterate, it's really important to couch any recommended conditions or findings within the development code and what Shane and Mr. Lindsay are going to put forward to us. And what's harder, in my opinion, is trying to suss out the emotion and the issues that non-land use savvy people are going to potentially bring forward. Because like the ones that are going to come from opposition folks, if there's money behind it, they're going to come with a really, really good attorney, and they're going to come at you with the whole entire development code and tell you why Shane's a big fat liar on everything that he wrote, and try to sway this body to say, Shane, sorry, you don't know what you're doing. We're going to go with the attorney side, but a lot of it's just patience and listening through the emotion. I know I've watched Commissioner King go through this with applicants when she was staff, trying to go, okay, wow, how do I draft this condition based off of this, right? And so it's complex, but we'll know. I mean, like if the suits show up with the briefcase, we'll know we're going to have some fun conversations. But if it's mostly neighbors and stuff like that, for the most part, it's trying to suss out from that. Now, we don't have to suss out the applicable substance criteria for people in favor or in opposition. But if we can, I think it's okay for us to say, we hear this is generally within the code where this fits. Shane, how do we create a condition of finding subject to that particular piece? So I think the bottom line is don't wait till Tuesday night to read your packet. If you have questions, ask early and often of Shane, Dina, and Mr. Lindsay, because I think that particularly as you're thinking about a potential condition that has been written, it's good to get those questions in advance. For one thing, it's just never super awesome to blindside all the smart people sitting over here, because it's not awesome. But yeah, it's gonna be fun. Sorry.
Yep, I appreciate that. That's honestly, that is something that I've had conversations with our hearings officers over the years. We've had a few different ones, and some at a hearing, they come with this big list of questions that they spring on me in the midst of a hearing. And I'm pretty quick on my feet, and I do normally know what I've written because I wrote it. But like, I do not have perfect recall. I never did, but I have a lot less perfect recall than I did when I was in my 20s. So, you know, I always ask, hey, if you look at that staff recommendation and you go like, hey, you missed the mark, or I don't see where this is addressed, or I've got just a question, like I don't see that this got talked about, let me know ahead of time, because that can help me when I'm giving a staff recommendation. Like, it is not, well, it's somewhat uncommon. I haven't had to do it too many times, but there has been several times in my career with very complex cases, because the staff reports get really long. You're bringing in, integrating information from our engineering firm, from our public works folks, from the fire district, from all these different agencies, and you're trying to get it all right, and you get kind of, you know, a little bit snowblind in the midst of it. So there's times where I may come with a staff recommendation that was published, And the night of the hearing, I'm walking on modifications to recommended conditions because I found something that I went, oh shoot, I just reread this and I realized I completely forgot to lift a condition out of the findings and put it in there. And so if you have those questions, and I'm sure that you will with these types of applications, the big ones, they are complicated. And so I 100% welcome the questions. No question is a bad question. It also really does help the hearing go better. You know, I mean, I have an application that's not even complete right now that's been applied for in my office, and I have had neighbors in my office 5 times asking questions about an application that is not complete yet because there is a high level of interest. And like, you know, we're very, like I try to be very transparent and open about that. But so I fully expect the room will not look like this when we have these hearings set, right? Like we may have the TVs on out in the lobby even, you know, it's that kind of a potential to be long nights, which also means I would just implore you all as planning commissioners and the chair, like we'll have the limit timer out, but like they get their 5 minutes and then, yep, next, you know, right? I mean, it can get long. So we'll buckle up and it'll be great. But yes, please send me questions ahead of time if you have them.
Do we have a rule that basically says if like there's a body coming in, can we ask a representative of a body? So if we get like Friends of Claggett Creek that come in and they decide they're going to bring a form letter and 20 people want to read it, do we have a rule that allows that?
It says persons in favor, persons opposed, and others, 5 minutes a person. I mean,
Please don't read your.
it doesn't,
testimony.
I mean, I've seen where people try this, where it works in our rules, and unfortunately, we don't have it here in our rules currently, right? But citizen comment, you know, is an area where usually they give 5 minutes per person, but sometimes if there's a huge amount of people, they say, hey, can everybody, if you can't say something new, can you please not just say the same thing? And they have the right to be able to sit there and say it, but equal time, you know, under the current rules, but you could say, hey, if it's not going to be new evidence, we're going to consider all the evidence in front of us. And then sometimes they'll say, well, I want the weight of that evidence, right? So I want 2 voices to be saying this, but okay, can I consider it to be doubly weighted? Because now I consider 2 people would have said this.
It's plausible we'll have a sense based off of written communication prior to the hearing.
Yeah.
So if, like, what I would say is if you start getting form letters and stuff like that, like, maybe it's worth asking the question, like, if we're gonna have 20 people come in and they're all gonna read the same thing, there's nothing inappropriate to say, look, if all 20 of you are gonna read this exact same thing, can we just ask for a representative to come up of the 20 people and read it one time for all y'all? Right.
Yeah. And you can ask for that. I'm just saying.
I mean, in the interest of,
Yeah.
yeah, I mean, they may say no, but right, like.
Yeah.
Yeah. Well, Shane's bringing up a really good point too, is that if somebody in particular, if it is truly a group, then the group probably wants the standing. If the individual wants the standing, maybe they're like, well, I at least want to get on the record and say what she said.
Well, then they can go in the back room.
You know what I
and
mean, or
write all the
whatever.
names down.
So I mean, it is, because some people might want that ability just in case they want to appeal it. If it's made part of the record. Yeah.
Like literally, I mean, and I'm just, like, I'm trying to think expeditiously, because I've seen these things, I've literally sat in FSEC meetings, it went for 4.5 hours where we had one group of the friends of somebody that
Yeah.
read the exact same form letter for
Oh,
4.5
man.
hours.
Yeah.
And so like, if that even
Yeah.
becomes a thing, I would love the opportunity for Dawn to be able to have a sign-up sheet and say, look, if y'all are part of this chain
Yeah.
thing, please write your name and all your relevant information to claim party status. And if y'all are okay with it, we'll read it one time, I'll read the list of names, everybody then theoretically has party status, right?
Yes, they would have party status as a participant. What I'm saying is, as the rules are currently configured, each person could hold you to the 5
They
minutes.
could,
Yeah,
they
yeah,
could.
Yeah.
But I mean,
You can
but
always
if-
ask.
But if as a
Yeah.
group, they say, yeah, we're totally fine with that.
Yeah.
Yeah, and I mean, and I do think that's a pretty common one at subdivision hearings. You'll be a
Right.
group of neighbors that they maybe all sign up but then the first person
send one person,
speaks,
right.
addresses all of their stuff, and they go, ditto. I didn't have anything more to add, and, but yeah, so I think that is fair for you as the chair. I think we will double check, we will talk about it some more to see what the parameters are of what we have the true authority to do, but I do think
Yeah.
probably if people show up, they have a right to have their 5 minutes.
Agreed, but I
Right.
mean,
But yeah, I think
if
it's,
they want
like, we asked a question, they
Yeah.
waive it,
yeah,
whatever, then,
Yeah.
we get them on the record.
for sure. I think it's a
Yeah.
good strategy, especially if it's a real full house, so.
And I would also ask if anybody's just gonna read their written testimony, please just don't. You got nothing new?
Deliberations. Immediately following the hearing, the planning commission, sorry.
Yeah.
So, and sorry if this stuff, it's only one subject, but it's actually enough to kind of make your mind spin a little bit. So if you have follow-up questions, please just email me.
And again, it just goes back to early and often, right? So if you get this and your head's spinning, talk to Shane, talk to Mr. Lindsay, get out there in front of it. I mean, if we're being honest, we're gonna lean very heavily on Lindsay and Jeremy to carry all of this for us.
You better
So,
bring snacks then.
yeah, turkey. Actually, Talia's gonna do all the work. No?
Bring some summer sauce.
Okay, so we've been through all this. Commissioners, is there any questions or follow-up, ideas, thoughts, concerns for Mr. Lindsay or Mr. Witham? And also, speak really clearly next time, because like, when we're in the hearings, because we make Dawn's life much simpler when we're clear and articulate.
I would just add one thing. If we have something that's going to be highly controversial, I would recommend to all the members of this commission, be very careful what you say everywhere, because the walls have ears,
Oh, yeah.
and it will come back and get you. So just a word of caution.
Well, and I think that, like, to the extent that, like, so we make a recommendation to council, it goes to council, council's good. What's the appeal timeframe? I mean, basically, at what point are we like, okay, we're okay to like live our lives and be normal human beings relative to this? Is it 120 days? Like, what's the appeal timeframe after it goes to
Well,
city council?
So the appeal of, if you had a final action here, it's 30 days? No, to appeal to council usually.
Yeah, I mean, it depends on what the land use type is. Some
Yeah.
of them are just like 10-day appeals,
Okay.
or 14-day appeals.
And a lot of, that's a ton of the ones that you deal with. So I believe it, from here, I think you have a little bit more to try to put together. I think it's a 30-day for the most part, but yeah, some of them have different appeal timelines. So if you guys make a final decision, those are usually the circumstance that has slightly more time
Okay.
for them to get to because it's a bigger deal to then get ready for, higher. And then, yeah, after a final decision, say of the council, then Luba can hear it, or it has to go in, I think, within 30 days. And you might know that too. I don't have it off the top of my head right
Two
now.
follow-ups to that. So ex parte then still applies during any period from the final recommendation and through
No.
the appeal period?
No, because, yeah, well, after the evidentiary hearing is completely over with, then you're not being impacted and the decision's made.
Okay.
I guess.
But if Luba remands,
Yes.
or the
yeah,
council remands.
Thank you for that, because that's what I was
But
going to say is, if it gets remanded.
But it would most-
I guess you could just keep in mind that if it was additional information from what you heard the first time, you could put on the record that subsequent to these hearings, this person's come up and said this to me, I'm still gonna, move forward.
Yeah, I mean, I think probably I can't give real advice, but I can just think from a practical matter. Once your hearing's closed, you've made your recommendation, you're kind of done. So realistically, the norm would be it would go to council for the decision, and normally the remand is going to go back to the decision-making body. They won't remand it back to planning
For the
commission.
master plans.
They'll remand it back to council. Now, the only thing that could theoretically happen, the council has the ability, and this has actually happened to us at planning commission, where planning commission has made a recommendation and council said, yeah, you know what? Planning Commission, we want you guys to take this back up and think about it some more. So there could be that theoretical. So, I mean, probably the best move would be to sort of really kind of try to protect yourself until the council public hearing is done, just in case. But, you know, once a council hearing is over, that, you know, that LUBA remand is not going to come back to Planning Commission, I don't think. Like, I mean, council could choose to, but that wouldn't be necessarily the normal process.
Final question, media inquiries, where do they go?
What do we?
Media inquiries.
You guys, one of the challenges, and the council has this too, right, is that the body, one person doesn't speak for the whole body unless they're given permission by the body. So please don't presuppose that you're speaking for the whole body unless you've really gotten permission to speak for the whole body on a particular issue with a particular answer. And so the safest way to do that is just be like, you can contact, you know, the city, and if we have a PIO that wants to make a comment on it, we can. Oftentimes, it's not that helpful, right? Because, I mean, you could probably all agree in advance right now that, hey, we're an impartial body, and we don't even know because we're waiting to the hearing to even make a decision, because we're not going to make a decision unless we hear evidence. You know, so, I mean, there's some generalities of the way we want to operate and proceed, but if...
So when in doubt, send it to Shane. Got it?
Yeah. Yeah.
Because again, getting caught up in media, it's one of those things, Facebook comments, the whole 9 yards,
Yeah, yeah, yeah.
all that stuff will come back and get you on the posterior.
Yeah.
Okay, any other thoughts, witty statements, comments, remarks on this? Okay, just remember, please get questions early and often into Shane and Mr. Lindsay, make their lives better. Councilor Duran, Councilor Representative report.
I don't have much other than I want to say thank you to you for all the work you put into the Gold Star Memorial. That was an awesome event on Saturday. The unveiling of that great monument. So thank you very much for you and your crew's efforts in that. It was, I believe, a very, beneficial item that the city has. It's just, we are the first in Oregon to have a Gold Star Memorial, and I think that's a big deal, and you put a lot of work into it, so thank you.
We had family come out, or people come out from Virginia. This is, the impact of this is not minimal. I think that the actual ceremony itself was very sobering. I was fine literally up until the point that the Gold Star families actually started kind of talking about it, and then had a bunch of demons come back and kind of hit me in the face from my military days. It's interesting. There's a woman, she said, I was born in 1945. 4 months later, my dad died, and I never met him. So when you stop and kind of take the gravity of that into perspective, it's pretty important. And so I'm just, honestly, like, I kind of joked around at the reception after the fact, it takes a village to do really good work, and I'm just fortunate sometimes to be the village idiot. And I'm blessed to have been able to kind of work in this project. But, frankly, I mean, the efforts of you and Councilor Christopher and the mayor and everybody else that put all these fundraisers together, I think are really what got this moving. I will say, one of the things I'm super proud about, the Woody Williams Foundation said, for the record, this is the fastest project they've ever had. Start to finish, 18 months. They said most take anywhere from 3 to 5 years. They said they were shocked when we sent them the final check for the actual monument and said, let's get this thing moving. They really didn't necessarily believe it was real. It was so much so that Dr. Mark Harris had actually retired and was no longer part of the organization, but actually asked to come out because it was his last project that he had any involvement in. And so it was super cool. But we had almost 300 people there. It was raining and it was nasty and it was wonderful and all the things. So
Yeah, it was great. So,
Yeah.
Really, you did a great job.
we did. All right. Do you want to do council report on the 17th since Commissioner Hostler's not here?
Yeah, why not? I'm gonna report is that we
That's fine.
had a training session,
It was a good training session.
and thank you.
So are we on the 11th? March 11th? Are we meeting? Yes. Great.
We don't have to.
Well, if we don't have to be, then we don't have to be.
Do we have
I
any
just,
agenda item?
What's that?
Do we have any agenda items?
I don't have anything specifically that we have to address on the 11th.
can we change the rules to say group representatives can only send one person? Can we get that, get that done that fast?
No.
I'm looking at Joe. I don't know if that's not.
I'm kidding kinda, but also like, we don't need to meet if we don't need to meet.
Well, your rules are complicated in that you have the power to have your rules, but it has to go through council.
I know.
Like, subject to their approval. So we would have to do that and then
They would copy
go
our
to in front of the
same
council
rules
and then come back to you to actually adopt them. And so I think we're
All right.
several
Well, if we
meetings
don't
out.
have a,
So we really, right now at this moment in time, we could choose to say, hey, we're going to take March off, happy spring break or whatever.
commissioners by consensus, we okay with canceling March?
Yes.
Put a caveat on that unless something comes up.
Well, sure, right.
Yeah.
Subject to recall. You're not on here, but Talia, what do you got for us? Any fun?
There's not very much going on right now at McNary. Just sports are going on. The second semester's started, and everyone's just waiting to hear back from their colleges for the most part for the seniors. So,
It's that nervous time.
yes, very, very
Yeah.
nerve-wracking.
Well, I'm gonna say one final thing. Mr. Lindsay said, I'm the only Mr. Lawyer now in this building. That's really weird. Bill Lawyer retired, last Friday after 36 years of dedicated service to the city of Keizer. And, we'll miss him, but if you don't know Carrie Blaylock, get to know Carrie. She's awesome. I worked with Carrie in a couple different capacities. For the Watershed Council, she previously worked for Marion County, and then she worked for Keizer for a period of time. Carrie's great, and, really thankful to have her on board, and just want to say one final time to Mr. Bill Lawyer, thank you for 36 years. It was, it's weird to not have him here. Please, Shane.
I was just going to add, I think that is, he wasn't my first boss, but he was my second boss when I worked at the city. And so I told him last week, Bill has been around and he has institutional knowledge that no one else has. But I also kind of did want to let you guys know, I've had some good conversations with Mrs. Blaylock. And I think she will probably come to one of our future meetings, because I know we were talking about that. I said, I think it would be good, and I'd like to introduce you to everybody, and, especially as we embark on the TSP, and there'll be some involvement there, and she's going to be a very big part of that project. So I think probably, if we're not having a meeting next month, I'll see if April works for her to maybe show up and at least get to introduce, so you can put a face with a name and all of that if you don't know her. Because there are things where planning and public works, like in a lot of organizations, it can be an adversarial relationship that planning and public works has. It's never really been that way as much in Keizer, especially not with me and Bill, and it won't be that way with me and Carrie. And so, really, ideally, public works and planning is working in step with one another, and so that's always the desire, is to keep it that way. So anyway.
So since we're not meeting in March, two final things. February 23rd is a community listening session. This is for the Keizer Parks Master Plan. So this is specific to whether or not people want to see a pavilion at Keizer Rapids Park, and if so, where? And then lastly, March 14th, which is the Saturday after we would have a planning commission meeting, is our 16th annual Civic Center cleanup. So I've talked about it every year for probably the last 10 plus years. We get together on Saturday morning, 9 a.m. We pick up all the debris around the square block here, fill up a 30-yard debris bin, and it's been great the last couple years. The department heads have been out there. Whether or not they think that's great, I don't care. I'm kidding, but many hands make light work. It's one of those things. If you have skill in hedge trimming and things like that, Friday morning we'll be out there first thing, kind of actually going out and cutting all the debris down and stuff like that. But otherwise, 9 a.m. on Saturday the 14th. All skill, all ages, welcome to come and participate. It's a great event that happens every year. So rain or shine, it does not matter. We do it. Preferably not rain, because then it makes those garbage cans like 500 pounds. but I think that's it. Anything else for the good of the order? All right, we stand adjourned at 7:43.